So I think everybody's here. I hope everybody can hear me. I haven't heard anything, so I'm sure assuming all okay. So we will get started. So obviously we've been talking about Renters' Rights Act, Renters' Rights Bill, and Renters' Reform Bill. So we'll just go through obviously a bit of a timeline of what's happened there. This is where my laptop doesn't want to do anything. Sorry, apologies for that. So key dates being mind, we started talking about this, well, probably before May 2023, but that's when we first started doing webinars, going through the Renters Reform Bill was introduced. So that was the Conservatives' original bill. 11th September 2024, that then became the Renters' Rights Bill, and that's where Labour adopted it. And we had a webinar back in October of last year, I think, to go through that. And then the Renters' Rights Bill, as it still was, uh, received its royal assent on the 27th of October of this year. So I'm just admitting a few more people in while we're here. So it gave royal assent on the 27th of October this year. And so it is now technically law. So when something receives royal assent, it is passed as law. And then we have what's called implementation dates, which are what's coming next. So those are the key dates to be aware of. Quite honestly, you don't need to worry about the previous dates or the royal assent date. We'll talk about the dates that we do need to be concerned about as we move forward here. And I'm still admitting people, so I'm just going to make sure everybody's in. So yeah, that's just the dates, just so that you're aware. So this is now the roadmap that the government have released. Some of you may have seen the document the government released. It is publicly available. It's not something that's just available to us. As property professionals, letting agents, we get this information as exactly the same time as you do. We don't get any priority early access or anything like that. So we find out what's happening with new laws, legislations like this as soon as you do. We sometimes get a little bit of a heads up in property sort of professionals talking, but generally this is what we get. And we get it exactly the same time as you through sort of our bulletins and the standard BBC News and everything like that. So just looking through the roadmap, how the government set it out, 27th October, as we've just said, was when the bill received royal assent. So technically that's when it passed as law. 27th of December this year. So everybody's talking about this first phase one from automatically 2 months on from when their bill receives royal assent. Some statutory influence are coming into place, which is going to be the increased local authority powers, which we'll talk about shortly. How many local authorities will actually be alive and kicking on the 27th of December? You can take that guess for it, but that is when they will have increased powers, which we'll talk about shortly. 1st of May 2026 is the date that we're mainly going to focus on this evening. That is obviously, as you've probably seen in the news, that is the first implementation date. Quick bullet point here, some things we'll be discussing, which are going to be coming in that it's the main start of the tenancy reform, so where all the big headlines have come in. No rent in advance and restrictions on guarantors, a ban on rental bidding, a little bit of a typo there, annual rent increases, which generally most of you are probably sort of literally already, right to request a pet, and no discrimination. And we'll go through each of those step by step as we go through this webinar. So then phase two, the government set out, which they plan to bring in late 2026, but they're going to bring it in two stages. So if you've been on my webinars before, you know they were talking about this new property private rental sector database. So that'll be coming as the first stage, and then stage two is the introduction of the landlord ombudsman, and I'll talk a bit more about what that is later on as well. And then actually quite surprised the industry is phase three isn't going to be coming in until 2035 to 2037. We thought this would be higher up on the priority list, but it seems that it's not. And that is the implementation of the Decent Home Standard, and then probably include AWAB's law as well. For those who've been in webinars before, we've spoken about what the Decent Home Standard and AWAB's law, which has been recently passed as law in social housing. We've talked about what those are and what those include, and we'll have a quick look at that at the end as well. But obviously, as we're looking at about 10 years away, I'm not going to dwell on that too much this evening. I'm going to focus on what we need to focus on within the next 6 months. Come on. Sorry, we're now going to have a technical issue, aren't we? Waiting for someone to come in. There we go. Don't know why my laptop's not very happy this evening. So we talked about that 27th of December. So yeah, straight after Christmas. It's just an automatic 2 months there. There'll be new powers for local authorities. So this is where if some of you may have had experience before, if a tenant reports to council they're not happy with the condition of their property, it's giving them larger powers, sort of bigger enforcement action. So they will have the right to information about any property or tenancy. So GDPR will be out the window. They can request copies of emails, text messages, phone call notes, anything about a property. Or a tenancy in particular. It does include the right to enter a property to inspect or business premises. So they could be coming on to letting agent premises to ask to see files, to see notes, system notes. Same, they could just demand to go into a property. So that's just something to be aware of, that that is happening on the 27th of December. Local authorities will have the power to enter a property, to request documentation. If you've told a tenant you've done something, you've had quotes for it, or you've done works, they can request and have the legal right to see those invoices, documentations, quotations, whatever that looks like. Obviously, for all of you in here, all very good landlords, so you won't have any issues with this at all, I'm sure. But just make sure if you have got any outstanding maintenance, damp or mold issues, anything like that, that you are addressing them. Because this is where obviously local authority can come in if you've got any sort of battles with your tenants. Maybe worth speaking to us about them, see if we can help rectify that, because it's where they can then go to local authority and they have greater powers to step in now. So that's just something to bear in mind. 27th December, that's gone but relatively unnoticed. I don't think it's a huge issue. To be honest, I don't have a problem with it. I think, it's this bill was said it was aimed at rogue landlords in inverted commas. And I don't see an issue with local authorities having greater powers if there isn't, if there is a landlord that isn't looking after the property or their tenancy in the way they should be. So obviously for those landlords out there that are doing what we should be doing with all our legislation and keeping our properties up to date and in good order, I don't see that being a problem. But it's just something to be aware of for the 27th of December. Thoughts, words. So we're going to phase one now, on the 1st of May 2026. As we've said, when I've used my crystal ball before, we're still talking about January 2026, possibly April. So May, we can't complain about, but we don't want to be complacent either. So yes, it is now 5-ish months away, 5-6 months away. That does seem like a long time, but there's lots of things we need to prepare for and get ready. So we don't want to sit be complacent about it. We do need to start thinking about what we need to do and what tenancies we have now, what they will look like come the 1st of May, and how things will change when that date comes. So everything will go to an assured periodic tenancy. So this is where we talk about tenancy reform. And tenancy reform encompasses a number of things, but this is where we said, with the end of fixed term tenancies as we know them. So there will be no more 6-month, 12-month fixed terms. Everything will become rolling from that date. So from the 1st of May, no matter what your tenants sign now. So you could move a tenant in this month, for argument's sake, for 12 months. Pretty pointless signing up for 12-month tenancy, because as soon as the 1st of May comes, that will automatically become a rolling periodic tenancy. No matter what, that will be law. So you obviously still enter fixed terms now. You don't need to start periodic tenancies now, but just to make you aware, on that date, no matter what you have signed currently, everything will become rolling. So we're pleased to note from what we've had from the bill that existing ASTs for short hold tenancies will still be valid. So you don't have to go out there and get new tenant agreements for all your properties on the 1st of May, which was good news, because we were slightly worried at some points that was going to happen. But what it does mean, obviously, there will be certain clauses in that tenancy agreement that won't be valid. But if you've got that tenant in your property now, and they're still in there, hopefully, if they're a good tenant from the 1st of May onwards, you don't need to change your tenancy agreement. It will still be valid. However, the government will be releasing a leaflet, it's called, which must be provided by any existing tenancies by the 1st of June. So you'll have a month from implementation to provide that to your tenants. Based on previous experience and knowledge and what we do, you would need to have proof that you've served that. So with us, we will probably be uploading those leaflets onto a DocuSign, like signable, like we use, and getting every tenant to sign to say that they've had that document. So if we do, what we'll talk about later when we go to, if you need to gain possession of your property, we have proof that that tenant has had that document. Because if your tenant hasn't had that document, or you can't prove that they had it, then you're not going to be able to serve a Section 8 notice and you're not going to be able to gain possession of your property after the 1st of May. So that's a really important part. If you are self-managing your properties, you are going to have to make sure that's done and that you have proof that you have served it to them. This leaflet, the government are saying they're going to release in March 2026. So we've only got a few months to get it out there. So for an agency like us with over 400 managed tenancies, that's a lot of admin work that is going to come into it, but it's something to prepare for. It would have been great if we could have had it from January. That would have been fantastic, would have made our lives a bit easier, but apparently it's coming out in March. So let's hope there's not a delay in that. So if you've got a tenant, an existing tenant on an existing ASTs and a short hold tenancy, you will not have to change your tenancy agreements. They will still be valid, although obviously certain clauses within them won't be. But you must provide this government leaflet, and I'm sure it'll have a much prettier name by the time it comes out, by the 1st of June 2026. Really important. And as I said, you must have proof that you've served that to a tenant. Just sending it to them in the post with no email sometimes, yes, though a tenant you have to be careful because the tenant can claim that they haven't got it or you sent it to the wrong email address. If you are emailing it, ask them to acknowledge back. If you can do it so you can meet them and get them to sign it and date it, much better. So you've got that physical copy in your hands and make sure they have that physical copy as well. So then if you have a new tenant moving in from the 1st of May 2026, there will be a new tenancy format. So they will all be assured periodic tenancy, so APTs they'll be called as opposed to ASTs. And the government are releasing key terms which must be included in these tenancy agreements. We don't have these key terms yet, but we will have them obviously in due course, hopefully sooner rather than later. Whereas an agent like us, we use a tenancy platform. So we use Rightmove's tenancy platform, tenancy manager, and they will automatically, obviously, multi-million, billion-pound company like Rightmove will have legal advisors working around the clock to make sure their tenancy agreements are up to date. So that's something really to be bearing in mind as well. If you're a self-managing landlord, tenancy agreement that you can get online isn't going to stack up. You need to be getting professional tenancy agreements done because they're brand new to the industry. And the government will probably release their own version, whether you want to use that or not. They do have their current version at the moment and nobody uses it. So take from that what you will, but it is something you really need to bear in mind. It's not going to be simple documentation. Another thing that probably a lot of tenants won't be aware of, and we are doing some releases on social media to make sure that tenants are aware of how actually this bill affects them, is a tenant will be required to provide 2 months' notice. So that's from the 1st of May 2026. Now, there is some talk about 2 months' notice unless the tenancy agreement states otherwise. So it depends in this leaflet that comes out. If that leaflet that the government releases says they must provide 2 months' notice, then that will be law for everyone. If it doesn't, if you've got an existing tenant on an AST and that notice says 30 days, like ours do, then that would still be 30 days would still be valid. But generally, I would try and think about the 2 month notice. A tenant has to serve that 2 months notice to expire on the rent anniversary. So if their rent is due on the 1st of each month, the notice would need to expire on the 30th or 31st of the 2 months' time. Whereas obviously at the moment, some tenants can serve notice on the 15th of the month, even if their rent's due on the 1st, and we just work out pro rata what they owe. So that's a main change from there as well, is that it has to be from technically thinking it in your head, rent due date to rent due date, if you're working on a calendar month rent system. And it would need to be 2 months' notice. Now, this 2 months' notice, obviously, because you're in a periodic tenancy from day one, can be served anytime. And yes, that does mean it can be served on day one of that tenancy. So your tenant could come in or come into our office, they've signed their tenants agreement, they could collect their keys, and they could literally hand us their 2 month notice at that point. And that is the risk that these new laws have. I think it quite unlikely, unless you've got a furnished property in somewhere very nice and sunny. Potentially, so there could be some, and much of our stock isn't fully furnished. And you've got somebody who wants a 2 month sabbatical down in Devon and Cornwall or something like that. Then there is obviously potential risk for that there. But then they're going to be renting somewhere and having to pay bills and council tax set up, depending on what you've got involved, fibre, internet, whatever. So I think we might see that a little bit more in fully furnished properties. But generally, this law was brought in so that tenants had the flexibility to vacate their property if it wasn't being looked after. But the government was also talking about one point putting 3-year tenancies in place. So they're arguing that it's giving tenants more control and should help them stay longer because they're in control of their tenancy. But that's an aspect I think we'll have to see how it goes with that. But just to bear in mind, your tenant can collect the keys on the 1st of May 2026, and they could hand their notice in to vacate on the 30th of June 2026. And then we'd be searching for a new tenant straight away. So it does mean we're going to have more void periods as well with properties. So if you are getting notice from a tenant, bear in mind it's going to be 2 months' notice. But then most other tenants looking as well, they're probably going to give their own 2 months' notice if they're currently in rented. So we're still going to be wanting to market those properties at that 2 month point. So it's just going to take longer. So obviously, let a property at the moment, obviously 30 days notice, you put a property on within 4 to 6 weeks, you've got someone moving in. But we're going to be more like 8 to 10 weeks, or 10, possibly even more than that, going how the months go, 4 or 5. So just bear that in mind when you're working out the calculations. Obviously, it shouldn't affect void periods because your tenants are still going to be in that property. You're just going to know they're going sooner. But just what you might be putting something on the market, getting a tenant all through referencing, signing a tenancy agreement, and then not a lot could happen for a month to 6 weeks. You could have a really sort of tumbleweed period where nothing's happening. But that's just because those notice periods is extended. So that's very much a whistle-stop tour on the tenancy reform. I should have set out at the start, but I'll say it now. I have got a link at the end of the webinar where we have a quick Q&A, because obviously I haven't got time. I'm sure going to be loads of questions to go through everything this evening. To book a meeting with me, if anybody has any questions or any concerns and you want to book a meeting with me and come and sit down, go for it in more detail. Obviously, there is a lot more detail to some of these aspects than I'm talking through in a webinar in an hour on a Tuesday evening. We will be doing other events as well. So there will be landlord drop-in events in our offices. We will hold face-to-face events. I will do more webinars. But if you do want to book a meeting, there is going to be a link at the end of here, and I'll email you all as well. So you've got a link so you can just book a meeting direct into my diary, come in and see me, and we can go through any aspect, all aspects that you're interested, concerned about, and bits like that. So I appreciate there's a lot of information that I am throwing at you this evening. So that's the tenancy reform part mainly. Repossessions. So this is what has hit the headlines. It's obviously about Section 21 being abolished. So that's what obviously the media have hold on to. That's probably the biggest questions we get asked is what do you want to do if we get the property, if we want our property back? So what to bear in mind is everybody sort of thought, because the Renters' Rights Act's now law, that you can't serve a Section 21 at the moment. You can. And you can serve a Section 21 notice up until the day before the Renters' Rights Act is implemented on the 1st of May. So you can serve it up until the 30th of April. Now, just bear in mind that service is normally at least 3 days before by first class post. If that's how your tenants agreement states, you can serve it. So there aren't going to be many going out on the 30th of April. It's going to be a few days before that, but you can't have up until that date to serve it. The government have also said you have 3 months after phase 1 has started to start possession proceedings. So if you serve that notice on the 30th, they don't vacate 2 months later, you've still got a month to apply for possession through the court. So that gives you to the 1st of August. So it's a short window, but it's a short enough window. If you want a tenant out, you get to the end of the 2 months, you should start possession proceedings straight away with a solicitor. Problem you are going to have is solicitors obviously do take some time to do their file checks to go through, depending on their backlog of work, all of which, if you've got loads of landlords trying to do this all at once, so that last month and that third month is going to be tight. So I'm not encouraging landlords to wait up until that date to serve notice. Well, I am saying if you've got tenants right now you're slightly unsure about, or something's not felt quite right, or they've been late a couple of times recently, you don't need to panic evict now. You've got time, you've got until April at least. You've got right to the end of April if you want, but you've got to the beginning of April just to see how those tenants get on, do your periodic inspections, see how rent payments come in over Christmas. We're in the classic month of the year where I have the biggest amount of rent arrears on our books, because obviously Christmas presents come first in most people. So we're getting to that stage at the moment where if you've got something you're not too sure about, or you're not sure, oh, I might sell it, I might not. As we've said to landlords at the moment, if you're getting notice in from a tenant, if you're considering selling, consider do it now rather than into next year. And we'll go through why in a minute. you have still got time. So no panic. If you've got a tenant that you're a little unsure about, or something's not quite feeling right, or you're not sure about what you're going to do, or you might need to move back in, you've got some time to play with. So please do not panic evict. But also don't leave it right up to the last minute, because you've got a really short window if that tenant doesn't vacate for you to apply for possession. And obviously, with the Section 21 being abolished, there are grounds on which you can still get your property back. And so there are new Section 8 grounds under Section 8 notice for you to regain possession of your property. The reason why Section 21 notice has been abolished is it's a no-fault eviction. So a landlord can serve notice on a tenant and not give a reason. So if you just don't quite like each other, or they've been a bit rubbish, or that inspection, I didn't like they've done that, I don't like how they're looking after that, you could just serve them notice and you don't have to give a reason at all. I need the property back. Political parties see that obviously as a negative. They see there's retaliatory evictions, unlawful evictions. So they're saying you can regain possession of your property, but you have to have a reason. And that's where Section 8 comes in. So Section 8's been around for years. It's just been used in the background. Because Section 21's been the easiest and quickest recently route to possession. But Section 8 will now be your only way to gain possession after the 1st of May 2026. So I'll have a look at what it looks like. So under Section 8, there are 19 grounds for possession. 1 to 8 are mandatory. So mandatory grounds mean the judge has to award you possession. And then 9 to 18, it says 9 to 18 are discretionary. So that be at the judge's discretion, you'd have to provide evidence. So that's where it differs. I'm not going to go through every single ground. If you want the grounds, you can go and have a look. I don't know all the grounds off by heart. Absolutely no chance. But are these the ones that are, there are some new ones here that come in. So 1 and 1A are new, and there is a 1B as well. They are new grounds that have been part of this reforming the Section 8 process that you need to be aware of, because these are the ones that I think we're going to see most action on moving forward. So grounds 1 and ground A are mandatory. Like I said, a judge must grant possession. As you can see in there, so ground 1 is the one we've spoken about before. If you've been on any other webinars, is the landlord or a family member intends to move into the property. So the difference with ground 1 is you have to give 4 months notice, and this notice cannot expire within the first 12 months of the tenancy. It's because the tenant has this restricted period for 12 months, a protection period, I think the government are calling it, a protection period of 12 months in their tenancy where they cannot be evicted. So you could serve out the notice at month 8 for it to expire, it would just expire just after month 12, for a family member to move in. Now government have also in their guidance released what a family member is. And I've written it down just to make sure I go right. So technically it's a blood relative. So it's a spouse, a civil partner, a child, a parent, a grandparent, or a sibling. That is it. So there's no aunties, uncles, cousins, nieces, nephews, long lost friends. It is yourself or a blood relative, as in very close blood, moving back into property. How they're going to police that, I don't know. But I'm sure we'll get guidance on that further along. I don't exactly know how they're going to police that, but that is what they've said. Ground 1A is the landlord intends to sell. So a lot of people have asked me, but what if I want to sell? So again, it's the same. It's a 4 months notice, and it's that 12-month protected period. So you could serve it in month 8 to expire at month 12. That's where I've said that to landlords, if you're thinking of selling, give it a little dabble now, because then you've only got to, you wait for your tenants and you can give them their 2 months notice, and you can do it that way. The main thing to bear in mind with grounds 1 and 1A is a restriction on reletting the property for a further 12 months from when you regain possession. So when that notice expires, we generally be if a tenant's still in the property and then you have to go possession proceedings, you've got to wait 12 months after that. So you've got a 16-month period at least there where you can't relet that property. So that's why I'm saying now is if you're thinking of selling, you're dabbling now, dabble, because when you get into May 26 onwards next year, you're going to have to, in my head, you're going to have to sell that property at whatever price you need to, because otherwise you'll be paying council tax, mortgage bills, potentially for at least a 12-month period, if not 16 months. The government has said that a property obviously can be relet if there is a reasonable evidence that you have tried to sell the property. Again, I don't know what that's going to look like. I don't know how you're going to prove that. There will probably be restrictions like it must have been on the market for 6 months and you've done X amount of price reductions or something like that. So there is slight leniency there, but not so much. So those are the two main grounds that I've been asked about, ground one and ground 1A. So the landlord of family member moving back in, family member must be very close family member, blood relative. Ground 1A, yes, you can still sell your property. Both of them are 4 months notice. Both of them have that 12-month protection period and you have restriction on relet for 12 months after. So that's really important to bear in mind. In terms of rent arrears, ground 8's always been there under Section 8 anyway. But it was that a tenant had to be 2 months in arrears when notice served and possession in order for it to be valid. That's going up to 3 months in arrears, and the notice period is going up from 2 weeks to 4 weeks. But you can serve it at any time. So if a tenant is 3 months in arrears, you can serve a Section 8 notice under ground 8. However, what many of you may know if you've been on a webinar with me before or you've tried to serve a Section 8 under ground 8, as soon as that tenant must be in 3 months arrears when you serve a notice and when you try to gain possession, when you go to court for possession, or when you're given your possession date. If that tenant pays £1, they're no longer 3 months in arrears and that notice is completely invalid. So that's one thing to bear in mind, is that it doesn't matter if they are 3 months in arrears and then they decide to pay you a fiver, they're off the hook. They're no longer in arrears. So there is also ground 10 that you can use. But again, ground 10, remember earlier, ground 10's a discretionary ground. So it will be up to the judge to decide. They don't have to give you possession. And there was talk about tenants being 2 months in arrears 3 times in a 12-month period, then just about a discretionary ground being given, and you've been able to get possession back that way. So I think we will see ground 10 being used a bit more, where there have been persistent rent arrears. Because if you can document that and you've got if you're using an agent like us and you've got your rent statements and you can clearly show that someone's persistently been in arrears, you may have some stance under that. There's just no guarantee at the moment, but there is no restriction on when you can serve that, and again, it's 4 weeks notice. The other one that's point is ground 7A is serious antisocial behaviour. There's no notice required, no restrictions. You can go possession order straight away. However, serious antisocial behaviour is serious criminal activity. It can be used if a tenant goes to prison. If they're on bail, they're not going to be if they're not released on bail. Serious antisocial behaviour, which is going to be difficult to prove, or to say to judge, I need because of that, because of GDPR and police giving you police logs, but they have introduced a ground in relation to serious antisocial behaviour. You could get possession of your property. There's no notice required. You could go to court and say, I need possession under ground 7A because of this. And a judge would have to award you possession with no notice. You wouldn't need to give a tenant notice. You could gain your property back pretty much immediately. But we'll see how that one moves. Hopefully, we don't ever have to use that ground. I've never had to use ground like that before. Hopefully, we won't have to go there. One thing to remember with Section 8 grounds, you'll hear it if you're doing other webinars or speaking to other property professionals. Legal advice should normally always be sought when you serve a Section 8, because if they're served incorrectly, if you haven't served that leaflet that we've discussed at the start of the tenancy, if there's something wrong with the paper file, the judge will just not award possession. End of. There's no leniency. So it is about making sure you have all your ducks in a row, in order to move forward with that. Those landlords of us that have got eviction cover, obviously we're currently talking to our insurance provider at the moment about developing that, and making sure that they will provide cover under Section 8 as well. So it's worth, if you have got a managing agent who are interested in speaking to us about our premium management or eviction services that we can offer, there are premium packages coming out there now which will cover these areas. One good thing about the Section 8 notice, is that you do have 12 months to rely on the notice. So if you serve it and your tenant is 3 months in arrears, and then, like I say, they pay a five and they're longer, they do it again and they're 3 months in arrears again, you can then go back for possession again, or any of the other grounds under Section 8. So you can still use it. A bit like Section 21 now is valid for 6 months, as Section 8 is valid for 12 months. You can consistently use it that way. Conscious for half an hour. Okay, we're doing okay. So that's very, again, like I said, whistle stop tour of the Section 8 and regaining possession of your property. There will be the link at the end of the webinar to book a meeting with me if you want to discuss any of this in more detail. We'll be doing a quick Q&A at the end, but it will only be sort of 10, 15 minutes, so I can't keep everybody all evening. But just any questions you can pop in the box, I can try and answer them at the end. If not, do book a meeting with me at the end of the webinar. We can go through it in more detail. So another thing that's gone quite the radar, rent in advance and guarantors. So there's some big changes here, which I think will affect tenants particularly significantly. So one main thing is rent cannot be requested until a tenancy agreement has been signed. And if a tenant does pay rent, then we have to refund it to them if the tenancy agreement hasn't been fully signed. So what the government's saying is no rent can be paid in advance at all until a tenancy agreement has been signed. So a bit risky that a tenant signs a tenancy agreement and then never pays any rent. It's a slight risk, but we do sometimes these days because a tenant has to sign a tenancy agreement within 14 days of their holding deposit being paid. So it's sort of around already. But yeah, the change is if a tenant does pay it before they sign a tenancy agreement, you would have to, by law, and otherwise it's an unlawful payment, will refund them that rent. You cannot hold it. Biggest change, which I think is going to cause the biggest issue, is only 1 month's rent can be paid in advance. And only 1 month's rent can be requested by the landlord. You cannot make any request for any rent in advance. So if you've got tenants that perhaps are moving to England from another country, they're moving down to Devon because they're changing jobs and they might have sold the house, so they've got money in the bank, but obviously haven't got any jobs yet, so they normally pay 6 or 12 months rent up front. We have some people retired that just want to pay 6, 12 months because their pensions aren't great, but they've got money in premium bonds or savings, whatever it looks like. We will not be able to do that. We cannot request it as a landlord or a property professional. It will be illegal to request any rent in advance. However, there is nothing currently in the guidance to say that a tenant can't voluntarily pay it. However, they cannot pay it at month one because month one is restricted to 1 month's rent in advance. So we can't ask them, or no, we can't ask them anyway, but if they want to, they volunteer to pay money up front. You say, well, that's lovely, but if you'd like to do that, you can do it for month two. But if they don't do it at month two, say you agree they pay the first month's rent, and at month two, you've agreed they'll pay 6 months rent because they've offered. You haven't asked, they've offered. If you get to month two and they don't do it, that you cannot make them. It will be a legal offence if you ask them to then pay the six. If we cannot email them on the second month saying you've said you pay 6 months rent up front, you now haven't. It's a voluntary thing. If they choose to do it, they choose to do it. You cannot make them do it. So unfortunately, I do feel there's some tenants out there which, the rent in advance was an easy way for them to get round, like I said, changing circumstances, changing location, changing jobs. If someone had bad credit from a previous relationship, they could pay some rent, but they have money, they pay rent in advance, come past that. But, we have some tenants that pay 6 months rent blocks in advance. But those tenants, those new tenancies are going to struggle. If you've got a tenant at the moment that's paid you money up front and that money up front goes over the 1st of May 2026, don't panic. You don't have to refund anything. If it's already been paid and it's already part of a current AST, you don't have to repay it. If your current AST states that they pay their rent 6 monthly in 6 monthly blocks, you don't have to change anything. Those clauses are still valid until you renew that tenancy if you decide to do so. So if you've got a tenant paying every 6 months and that's their agreement, that's fine if it's a current tenancy. However, anything new going forwards, obviously you won't be able to do that. Another thing that's gone relatively under the radar is guarantors. So we've got some landlords now that just ask for a guarantor as a matter of course because it gives them extra protection. I think sometimes some mortgage products actually have that on and ask for a guarantor. You will not be able to do that anymore. You can only have a guarantor if a tenant requires one. So and that would normally be if their affordability is just under, so they would only pass referencing with a guarantor, or if they've got bad credit, I think something's under £5,000, and to pass referencing they need a guarantor, or if they're on probation. That's literally going to be it. It's the only reason you can have a guarantor if the referencing states that they need one because their affordability is slightly lower. They've got a bad credit rating, but it's not huge. It's normally just one CCJ. That some referencing companies will pass with a guarantor, and if someone's on probation then they will do that as well. They will normally ask for a guarantor. So for those landlords out there that at the moment ask for a guarantor as a matter of course, you won't be able to do that from the 1st of May onwards. We have some tenants that offer them as a matter of course to try and push their application. If they don't need one, even if a tenant offers one, you cannot accept it. A guarantor can only be a guarantor if they are required to be one. So that's sort of a big change as well. And again, that's going to not have some tenants that would offer that up as an extra level of paying rent up front and having a guarantor as an extra level of security because they know a landlord wants that security. So that's another aspect that we do really need to take into account is think about you're not going to be able to get rent in advance from a tenant and you're not going to be able to have a guarantor unless they need one to pass. So just think about that. You only have 1 month's rent in advance. If a tenant chooses to pay rent after that in advance, that's up to them. But even if you've had an agreement and they've said they want to do it and then they don't, we've got no cause with them. We cannot request that payment. It would be an unlawful payment, technically under the Tenant Fees Act. So that's rent in advance and guarantor changes. Ban on rental bidding. So we haven't seen that so much, and I don't think we see it as much down in Devon necessarily, but we have seen it in some cases. So the advertised rent is the only rent you can accept or lower. So where we've had sometimes we might have a tenant view the property and they know because we've done back-to-back viewings as we do with most properties these days, and there's been 5 or 6 other applications, they go, well, that's fine, the property's on the market for 950 for them, say I'll pay 1,000. And the landlord goes, thank you very much, I'll take that tenant. Well, that's what they're trying to stop. I think it happens quite a lot in London, bigger city areas, Manchester, Birmingham. So you can only accept the advertised rent or lower. From that point of view, I think it will increase rents and we'll end up seeing offering. So we might see landlords saying, well, let's put it on at, 1,200, but I'd accept 1,100, but let's see what we get. But it might not happen to start with because we know tenants can be quite cautious around pricing, especially with rising cost of living. But I think we will start to move towards a sales line system where people will be making offers on properties which are lower than the asking price. And the asking price will be a rent, and that's where rents will rise because landlords will put them on at a higher price and still take probably slightly above what the market rent would be. So it's difficult to predict exactly what that will look like, but I think using my crystal ball, that's the way it will go, and we'll see people submitting offers for properties that potentially are on higher. I don't think, from especially our lands, I don't think we've had many of any cases of that this year. Possibly just after COVID, we had a few cases where we had people desperate for property, but it's just something to bear in mind. What you market that property at, you cannot accept any higher. And if you do, and a tenant then reports you to local authority or the ombudsman's going to, you will be subject to a rent repayment order and fines. And the first fine starts at £7,000. So we don't want to be doing that and go up to £40,000 for repeat offences, repayment orders, which can be up to 2 years worth of rent. So we don't want to do that. So just make sure you're aware of that one. Rent increases. So rent increases in my life are going to say pretty similar. So it depends on the tenancies that you have at the moment. So rent increase must be used serving a prescribed form. So at the moment we serve all of ours with Section 13 notice. There will be a new version called the Section 13.2. So they will have to be in a prescribed form, which the government will release, which is standard with notices we use at the moment. So any increases in your current ASTs will be invalid. So that's one of your clauses in your tenant agreement with a current tenant. So those are clauses that say at the anniversary of the tenancy of 12-month period, the rent will increase by 2.5% or 5% or in line with Bank of England base rate. So they will, with their automatic rent increases, so they obviously will be invalid. You won't be able to rely on them. At the moment, we need to give 1 month's notice by law to the next, 1 clear month to the next rent due date. We would need to give 2 months. A lot of our landlords give 2 months or longer anyway. At the moment, because they like to give tenants as much notice as possible. So I can't see this bringing many issues extending that period. You can increase by law now to market rent. So sometimes at the moment there are clauses where you can increase a fair amount. I think it's about, and some tenants agreements will say up to market rent, but the law will be no matter what your tenants agreement says, a landlord can increase to market rent. But the really important thing here is evidence, because a tenant will have access to the first tier tribunal for free. And that means a tenant can get a rent increase, they can send it off to the first tier tribunal, and well, within 2 months, they've only got 2 months to challenge it and say, I think I'm being charged too much. And then obviously it goes to tribunal, and then a judge will decide whether it is in line with market rent or whether it's not. If it is, that's great. The new rent starts and it can be backdated. Um, but tenants are going to have access to that, and all the charity shelter will be a shelter about tenants having access to that. So I think it's really important that we evidence the market rent and the increases that we're giving. So even if you're giving an increase below market rent, which a lot of landlords do with a good tenant, they sort of just up it by £50 as opposed to 100. We're talking about sending these best price guides which we can get as agents, and these property reports to show similar properties are achieving this in your area. So your landlord's increasing it to this because they want it in market rent, or that you're still below market rent. I think it's sending that evidence with that section 13(2) notice is going to become really important to avoid the first tier tribunal and to avoid any problems with a tenant trying to dispute it. One thing that the law has made clear is that if you agree any amendment, so we do have sometimes where a landlord was submitting a rent increase and then the tenant will come back and say, oh, this has happened, can I have 1100 as opposed to 1150? And the landlord will go, yeah, that's fine, and that's fine, it doesn't need to change, we've got an agreement in on an email, and we go ahead with it. From obviously when the act comes in, it will need to be in writing, so there needs to be a formal written agreement. That you don't need to reserve the section 13(2), but there would need to be a formal written agreement that the rent increase has changed to X. So that's just something to bear in mind. A lot more admin around the section 13 notices. Okay, so only a year, we're pretty used to that anyway. 2 months notice, so just slightly up, but it's the evidence side of it, which is going to become really important. Another one that I've been asked a lot about, obviously, the tenants will have the right to request a pet. And they can request that from day one. So I've said you don't, on an application, you don't have to accept them because they've got a pet. You could go with someone else. However, from day one of that tenancy, the tenant has the right to request a pet in the property. You have 28 days, apologies, to respond to it. And if you refuse, you have a further 7 days to explain refusal. So you can just send back to them in writing. So a tenant has to send to you in writing their request for a pet. They should have details about the pets, the type, the age. Government are recommending that they have sort of medical history, vaccination history, behaviour history. Obviously, they have to disclose if it's a breed that requires a license or a banned breed. And then you will have 28 days to consider that. And then you need to put a response back in writing. And that response can literally just say refusal. And then you do have a further 7 days from that to explain your refusal. Now, the government has provided some guidance on this. So you can refuse for an allergy, but you have to prove the allergy. So I know a lot of my landlords are suddenly going to become allergic to cats and dogs, but under the guidance, you have to prove that allergy with medical records. So if you went back and said, no, I'm allergic, the tenant could go, right, okay, I'm going to present this at the first tier tribunal, and you have to submit medical records to prove that you're allergic to that cat or dog or guinea pig or rabbit or whatever it is. What was the other ones? So the property's not suitable, welfare of the pet. So if you've got a top floor flat and someone wants to move 2 dogs in, you've got no outside space, that's fine. And obviously any other reasonable bits around that. Phobias was on the list. Now, sort of in my eyes, that sort of falls under allergies because otherwise suddenly all my landlords are going to have phobias of dogs and cats. So I think that's probably going to come under the medical side of it as well. And head lease is the most important one. So if you do have a block of flats, I've got a flat in sort of in a converted block, and the head lease on our lease says there's no pets in the building. So if your head lease says there's no pets, then that is a good enough reason for refusal, because obviously then you're breaking your own lease with your freeholder as a leaseholder. So that's fine. So there are reasons out there. I think it'll be interesting. There will be case studies which will help when this comes into it. But essentially, the government are trying to get us to accept pets. We're quite frugal with it as well. We're saying to landlords, if you've got a family and they've got a dog, they've got a cat, sometimes it's family home, it's giving more longevity. And we can go through in that way. So it is worth considering. So Steve just asked a question, will product restrictions apply to current ASTs or only new rules? It will apply to everything. So from the 1st of May, that is the law, Steve. So you won't be able to say no to pets in any tenancy. From the 1st of May, that will be law. Well, you can say no, but you have to have a reason and you have that time frame to give that. But it will apply to everything from that date onwards. Obviously, there was talk, if you've been on previous webinars before, about landlords having the right to request insurance from a tenant for a pet or taking out their own insurance and asking a tenant to pay that. Labour struck that out of the bill, so that's no longer there. So you cannot ask a tenant to take out Pacific's pet damage insurance. You can take it out yourselves, which I would encourage you to do so as part of your landlord's insurance. So I'm sure we'll see landlord's insurance is buffering up for that as well. But you wouldn't be able to put that charge back to the tenant, and still deposits will be kept at 5 weeks rent. There was some talk at one point about pet deposits in Parliament, but that got struck off as well. So it is a 5-week deposit. If you want additional insurance to cover yourselves for any damage, you will have to take out that insurance. You cannot insist on that on a tenant. Oh, no, it's gone. There we go. So discrimination is another area that's coming up quite a lot. Sort of falls under the pets bit, but you cannot unlawfully refuse an application due to a tenant claiming benefits or having children. So if a tenant is on benefits, their credit rating is absolutely fine and their benefit income is enough to pass referencing, you have to accept their application for the property. Now, if you have several applications for the property and you have, say, a tenant that's more fair, a couple that's working full time, you can accept their application. But if you have that one application, you cannot discriminate against that tenant. If you have, that tenant that's on benefits and you've got a couple and you've got somebody else and you go, actually, I like Mr. and Mrs. Smith, they're doing that, they want to move in sooner, I'm going with them. That's fine. Just go back to that applicant and say we've chosen another party. But we obviously cannot advertise that we do not accept benefits, which we don't do anyway now because the law, and every property within reason, obviously, again, has to accept children. So you can decline children if your property is not safe for them and not suitable. If you've obviously got a balcony that they could fall off at under HHSRS, we'd have to be careful with that anyway. But most cases, you're going to be needing to accept children in properties. I don't really see that being as a problem. I know I'm a mum myself, but I think we do have some properties where there's sort of 2-3 bedroom and they don't want children in there, and we're in the middle of a housing crisis. We need to be housing families, so I don't see an issue with the children bit. I do understand landlords' concerns around tenants on benefits. Obviously, we would have all heard about the budget last week. Benefit apparently is going to get increased even more. Benefit is a guaranteed source of income for these tenants, and for a lot of them, especially those on disability benefit, it won't ever change. It won't ever get taken away from them. So it is worth considering these tenants because they do have arguably higher guaranteed income than some of those tenants that are working. So I see where the government are coming from on the stance of this. But again, that tenant, if they are on benefits, they do still need to pass referencing. If their affordability isn't enough, if they're claiming obviously part universal credit, perhaps working part-time, and they're not earning 30 times the rent and they're not going to pass referencing, then you can decline them because they cannot pass referencing. So there are still reasons there. We're not sitting there and slapping it and saying you've got to accept everybody and anybody that puts an application into property. We just have to be careful with how we're accepting people, what we're accepting, and the language obviously using between us as well to make sure that we're getting that right. And like I say, if you've got a tenant that's on benefits and they can pass referencing and everything else, it's fine. Credit rating is good, landlord reference good, then we should be accepting them for a property. We do appreciate there are some insurance products out there, landlord's insurance and buy-to-let mortgage terms that will state that they can't have anybody on benefits. This is overridden by the new law. So those clauses in any sort of insurance or mortgage terms that you have overruled by the Renters' Rights Act. So unfortunately, that can't be used as an excuse either, which I know some landlords have used before. Unfortunately, they will be null and void, and you will still need to consider those tenants. So that's stage one going through. So that's what we've got to bear in mind and pick up ready for 1st of May. Lots of little things that are going on there. Hopefully I managed to explain that in 52 minutes quite well. So I'm going to steam through stage 2 and stage 3. So we've got a bit of Q&A at the end. And as I've said, I've opened up my diary for bookings. So you can book straight in my diary if you want to come and discuss anything else or a telephone consultation, whatever you need. I'm therefore, because I appreciate there's a lot of information and I'm having to talk quite quickly and steam through this. So stage two, as we discussed right at the start on the roadmap, is late 2026, it's predicted. Stage one will be the new PRS database, and stage two is the landlord ombudsman. And you will need to register for both. It's the landlord's responsibility at the moment to register for both, and there will, of course, be a fee for registering for both, probably an annual fee, an annual subscription fee. If you do not register for one or both of these, then if you go to service Section 8 notice, they are unlawful. So you have to have done these. And there are fines, as I said, £7,000 to start with and up to £40,000 for repeat offences. So it's really, really, really important to get this right. So the PRS database, as a private rental sector database, is a database which will include details about a landlord. So it's got to be careful with GDPR. So it's saying it's including things like landlord contact details. I imagine it will be a name. I don't imagine it's going to go any further. Property details. So you'll have to upload every property you own onto this database. You have to have the type, the number of bedrooms, number of residents in there currently. So whether it's occupied, not furnished, unfurnished, and copies of your EPC, gas safety, EICR. So it's going to be a huge database. Hence why I'm still struggling to see how 2026 is a possibility. With all the information. So it's basically a one-stop shop for tenants. So if they see a property on Rightmove or Zoopla on the market that they're considering renting, they can go on this database, check that you're registered as a landlord on there, because on all our advertising, we're going to have to put these little registration numbers of you as a landlord in your registration for the property. So they can take that number and search it in the database. They can check that you're there. They can check that it's got a gas safety and EICR, all the other information that's on it, and they can see if you're on a blacklist as well. That will be on there. There will be a rogue landlord list, so they can go on there and check that. It will also be a place when obviously local authorities have further powers and lose charges. If a landlord's ever been fined, if they've ever had a notice served against their property, my understanding is that that information will be on there as well under the landlord details. So it's very similar to what they have in Wales with licensing. We're going that way. It's like a licensing shop without the license, is the way to see it. The landlord ombudsman, we've spoken about that before. If you've been on previous webinars, that is like the TPO for us, the property ombudsman that we're registered with as agents. So if a tenant or a landlord aren't happy, they can report us to the TPO, and the TPO will investigate. There isn't anywhere for tenants who perhaps have a tenant find only property, especially, and their landlord's not maintaining the property, or they're turning up unannounced and they're coming home and they're in the property. There isn't anywhere those tenants can report to. So I am on board with this landlord ombudsman because it's helping those tenants where potentially there are rogue landlords out there. But again, you are going to have to register for it. That ombudsman will have powers to get you to write an apology, rent repayment orders, compensation, bits like that. But obviously, none of you are ever going to have that problem because you're here learning today about the Renters' Rights Act and you're all good landlords. But I am sort of in agreement with the landlord ombudsman. I understand that. I understand the premise behind the PRS database. But that's a lot of work. And that's a lot of information going on one database. So I don't know how any server in the world is going to cope with that. But we will see. So I'm just conscious of time, so I'm just going to move on to the next slide. But we will obviously, when we know more about dates on this, come in more detail. And then stage three, which you will be aware of, sort of, you've seen this picture before, you've been on webinars with me before. Obviously, we're talking 10 years into the future. Decent home standard and AWAB's law is currently at consultation stage at the moment, so you can go onto the government website and review the consultation. We're expected to receive guidance and timelines, etc. Once that's out of consultation. It is law in social housing at the moment, so we're sort of expecting carbon copy to go across from that. So AWAB's law coming recently, obviously, I'm sure you're aware of AWAB's a 2-year-old boy that died due to damp and mold inhalation in his social housing property. That's why it's called AWAB's law. So it's where a tenant reports damp or mold in property, the landlord has 14 days to respond. There'll be timelines and actions that they have to take. And there'd be certain standards that a property would have to uphold. So that's what the decent home standard and AWAB's law will bring in. I don't have a problem with either of those laws at all. The other thing they've snuck in with is meets the minimum energy efficiency standards. You'll all remember earlier when that a few years ago it was all upgraded to EPC rating E. Government is still now saying they're bringing it back up to the service. They want everything to EPC rating C by 2030. That's going to be a fun one. And those of you that have been on EPC webinars before we'll see sort of how big a jump that will be for some people. They have recently reformed how they assess EPCs. And so standards are very different now, but that's something to bear in mind. That's in the next, well, less than 5 years now, 4 years, that could be there. And obviously, when that was originally spoken about, they were raising the threshold payments from £3,000 to £30,000 at one point, and you have to spend that money in order to be exempt. So just have that in the back of your mind. If your property currently isn't a C, and especially if it's at the bottom of an E and nowhere near a C, you might still need to be thinking about speaking to a specialist in that area, which we can put you in contact with. I don't know that many of you were probably on Simon Jury's um, webinar that he did with me from Target CA2 probably a few years ago now, all about EPCs, but he's a very, highly experienced, knows his stuff professional, which will be able to guide you really well through that process. So we'll definitely get back in touch with him and get something else done on the EPCs when we know a little bit more, but that's just something to have on your radar. Right. So I've whistled through that in really, really quick timing. So I have obviously got up on the screen there the consultation booking link with me as well. I will email it all out to you. So I appreciate I have done just about an hour and I've steamed through like a steam train, quite literally, of all the information that I have. And so now I'm quite happy to take any questions for sort of next 10 to 15 minutes. And then I'll say anything else, please do book a meeting or just phone call with me. It is easier to book with me than try and ring or come in on a whim because I'm here, there, and everywhere. So it's much better to book into my diary for that. So I've got restriction. I've got the question in. Oh, William, thank you, Ali. So if anybody's got any questions, I'm going to unshare my screen now. And I really don't know why it's trying to. Ali, I'm really sorry. Why it doesn't normally do this?
That's all right, actually.
And it's now making everybody else at the front, not me. That's really helpful, isn't it? Sorry, Adrian. It's trying to make you look. I don't know why it's decided to like you. That's unfair. No. Right, let me bring up the chat box. Come on. Right, if we can put any questions in the chat box, just so anybody else talking over each other, that would be great. So if anybody has got anything, please do put your questions in the chat box. That should have popped up. Now I put that on there. If anybody has got any, I'll give you a couple of seconds. There we go. That's better. That's better. Lovely. So I will also, I said, I emailed about the link to book a meeting with me. I appreciate it's a lot of information to take on in a really short space of time. And I think it's, sorry, I've just had a question there, so I will go up through there. Will a landlord be able to say cat's okay, but not a dog? You have to have a reason for not the dog. The legislation states no pets, so it's difficult to say which way that would go. I would say no, and I think your landlord will consider a cat, but not a dog. I understand what you're saying, and we have landlords that do that at the moment. I just think you're still not accepting a pet. So I think there would still be an issue there if a tenant did challenge it. Yeah, I think you'd have to say why not the dog. If that makes sense. So no, good question, but I do think it's still going to say it is a pet, so you can't discriminate against a dog versus cat. I think is where that's going to go. Could they ask for a lot of ferrets? Yeah, a ferret at the moment there is no definition of pet from the government, so there may be further guidance. At the moment doesn't like it, but a pet is a mouse, mouse, hamster, guinea pig, bird, rat, ferret. They could, and I think a tarantula, yeah, at the moment, pet covers any animal. Lion, tiger, llama. I'm sure it's all going to class as a pet. So they have to ask permission for any of that. I was if ferrets, you probably could have, unless you got a load of outside space that you it's not suitable for them. I think you could probably get around that. A lot of it's going to be trial and error. I think a little bit because we're not really sure how it's going to go, and it depends if it really does depend if a tenant does challenge you or you do send your refusal. We just have to have a good enough reason to really go with against that tenant. Tarantula's a bit different than just makes me cruel just thinking about it because I don't like spiders, but I can't really see a reason why you couldn't. I'm on the list that the government have released so far. There will be further guidance as we go along, but at the moment, with a tarantula, I mean, you can say it's got to be in a cage, box, vivarium. Um, but yeah, I think a pet is applying to everything and anything. I know when I was little, I had those African snails as well, and they probably that would apply to that. So, sorry, I've just had some more questions come through. Do you say that having a first rate to get back to you? That furnish probably, Robert. Other way round in a way. The only reason I'm saying that is because a tenant can give their 2 months' notice on the first day they move in. I think I'm just thinking summertime, and we've got some lovely properties down here. And if we've got a tenant in inverted commas that moves in, you've got a fully furnished property where all your bills are included. You might even have your Wi-Fi included, and someone fancies a 2 month stay in Devon for 1,200 quid a month. It's probably going to be cheaper than any holiday accommodation. So that's where I don't think the 2 months notice is going to come in be an issue. I don't think we're going to get many on day one. I do think those sort of properties are where we could get that. So yeah, I if you've got a property that doesn't need to be furnished and you don't need to have the bills included, they don't get you a higher rent necessarily anyway. So I would steer away from that and go more on your standard empty box for someone to make their home because if you've got that, especially in the summer, I think we could see some nice long holidays for people down in this part of the world. Right. So communal areas get for I think flats anyway are probably quite a good reason that Ali, that you could refuse a dog potentially because especially if you haven't got any outside space, I think you could go under welfare. I think that will be a reason. Or a good enough reason. And I think, yeah, if you've got to go through communal areas where there's other people, and I think there will be premise there where you've got other tenants in the building and you're worried about a dog because of barking, whatever. I think that's going to be a good enough reason. So flats with a dog, I think are quite straightforward, unless you've got a garden flat, then it's a bit of a different story. But I think communal areas with flats is very, you've got to put other tenants. If you sort of manage whole block of flats, you need to be bearing in mind all those other tenants as well. And the welfare of the pet because they're going to be stuck inside with no outside space, nowhere to go and run. So I think flats is an easy way out with the dog. I think. Lots of thank yous. Thank you very much. So I'm happy to stay here for the next sort of 4+ minutes and long. I don't want to keep everybody this evening. If anybody has any other questions, I appreciate you got to type. Will you go through that? And we're still learning all the time, guys. I'm on another webinar. It's a webinar on Thursday, which I'm on, which is a sort of a league one for us, which is a direct government Q&A. I'm doing another one on Monday, so we're all learning. There's all lots of bits coming out constantly, with further information. So, like I said, there will be further webinars. I will do more and really in depth on each little bit. I'm hoping as well, probably this month, to host us some drop-ins. So, say this day, just pop into Newton office and see me. Pop into the Exeter office, Teignmouth office, Bobby, and we'll be there. And also coming into next year, we will, as well as more webinars, I'd like to do a night one, if not possibly two, because obviously not everybody can make the same one, face-to-face landlord events where you can come in to somewhere or one of our offices and we can, have a chat with people. We can do some talks on bits like this, talk about how we're going to be doing, how we're going to be coping with the Renters' Rights Act moving forward. And, our life is going to change dramatically. My day to day and my team's day to day is going to be dramatically changed. Just like I said earlier, we've got 400 odd tenancies we're going to have to get that leaflet out to. And that's a huge amount of admin work that we obviously is brand new to us that we're going to have to do and facilitate and make sure, it's not just getting it out is the easy part, getting the tenants to sign certain time frame is also going to be difficult. So we've got right. So I haven't had any more questions. I don't think. It keeps telling me my microphone's changing. So, if everybody's happy for now, I'm going to leave it there. Thank you ever so much for joining me this evening. As I said, I will email everybody that booking link so you can book in to see me. If it's easier, just email me and say, Emma, can I see you at this date, this time? Or can we have a call at this date, this time? It's absolutely fine. I appreciate there's so much information and I've sort of gone over the top of all of it. And obviously, I can go into a lot more detail with people personally. I think my message really is don't panic. We've still got time. From what you see there, it's not that we're going around like headless chickens. We don't know what's going on. We do know what we're going to have to do. We do know what it's going to look like. For those of us that have been in this industry or have been landlords for a long time, it is really scary. It's a scary and a different change. No one likes change, do they? Everything. Nobody likes any change in any aspect of their life. So I think it's just us going to have to change how we work moving forward, how we deal with our tenancies, how we accept tenants, how we manage that tenancy process, how we manage our Section 13s, how we manage repossession if we need to. It's just going to change the way we work and the way we think. It's not going to flip everything upside down. Similar things have gone into place in Scotland and in Wales, and the market is still there. Landlords are still making money. They are still, lucrative with their properties. And as we know right now, there is a housing crisis and we have tenants calling out for properties. So, it's not a bad time to be a landlord. We still need those to be there. So I'll leave it to it. That's good for me. I'm just over an hour, so I'm pleased with that. I will email everybody out, like I said, with the booking link. And please do feel free to contact me. And I hope to see you on more events soon. Thank you. Bye.